Unit 12 Banker Customer Special Relationship, page number 10. First topic. Line, L-I-E-N. Line has been defined as a right of the creator to retain the possession of the goods and the securities owned by the debitor until the debit has been paid. Lien do not include the right for sale of goods or securities, so the retained by the creditor. Lien is available as a good and securities only, such as bills, checks, promissory notes, share certificate, bonds, debentures, etc. Lien is not available for depositors since depositors are neither goods nor securities. Type of liens. Particular liens. In case of particular liens, section 170 of Indian Contract Act, the creator gets the right to retain possession only for goods or securities for the dues have arisen and not for the other dues. For example, a watch repairer can withhold the delivery of a watch until he charges or repair the watch and paid to him. General liens, L-I-E-N, lien. The general lien section 171 gives the right to the creditor to retain the possession till all the amounts due from debitor are paid or discharged. This is available to banker, factors, wharfingers, autonomous of high court and policy brokers only. Condition for bankers' right of lien. Bankers has a right of general lien against the borrower. To exercise the right of lien and the possession of property must be obtained lawfully in the capacity of the banker, not to otherwise. A banker can sell the goods or securities after giving the debitor a reasonable notice. Feature of the banker's general lien. Implied pledge and right for sale. The creator generally lien, no special contract is required. It is always implemented unless there is a contact of the contrary. If any, the right to sell is also available under banker's right for lien because a banker's general lien tantamounts to an implied pledge. Limitation. The right of lien is not restricted or barred by law limitation. The Act only bars and immediately through court of dischargement and the banker has a right of lien against the time barren debts also. Ownership. Through the possession is the bank, but the ownership remains with owner when the banker exceeds the right. So if it is indicated through the agreement of or otherwise, there is a particular security we obtain for particular debt only. The general lies gets converted into particular lien, criminal extraction. When the banker exercises his right of general lien under Section Act 2409 or 2420 of Indian Penal Code, no crime action is available because there is no criminal intention behind it. Where rights can be exercised. A. The banker of general lien is available in case all goods and securities entrusted to bank in the capacity as a banker. The right is available in the case of those goods and securities that are standing in the name of the borrower. Right can be exercised by the banker for the dues of the same borrow or goods and securities remaining in its possession even after loan taken against them has been paid. Where the right cannot be exercised. A. Where there is any contact inconsistent with the right between banker and the customer. B. Where the goods and securities are insured by the banker in a trustee or as an agent. C. Where the goods and securities are insured for some specific purpose. D. Where loan is granted to the one person and the goods or securities are owned by more than one person. E. Goods and securities handled over the safe custody. F. Where the bills of exchange or other document have been handled over the customer with specific instruction to utilize the process of the specific purpose. G. In case of share given to selling them in future, the sale proceeds by the specific purpose. H. Where documents or valuables are left in bank's possession by the customer by mistake or negligence. I. Where the security are given to the bank to secure a loan but there has been granted, but not yet. End of page number 10. Page number 11. Banker's right of set off. The right of set off means combining of two or more accounts, say overdraft and fixed deposit, one of which is in debit and the other is in credit, in the same branch or in different branch. Subjected to certain conditions, the right of set off is called a situation of right, and it enables the debitor to take the account to a debit and allow him to overdraft by creditor customer before the latter customer could recover the debit deposit due to him from the debitor bank. Such right can be exercised subject to fulfillment of certain conditions. Notice. The right can be exercised only after sending a prior notice expressing the intention to exercise the right. Time for exercising the right. The right is normally exercised in the case of insolvency, death of lunacy of the customer, insolvency or dissolution, or film of liquidation of the company, receipt and garnish order or attachment order. Same capacity. It is essential that the account must be in the same and the name of the same capacity. Right, money belonging to someone else cannot be made available to satisfy personal debits of some other people. Partners or partnership. Where the bank account shows credit balance, the right can be exercised due to the partnership but when the firm's account shows a credit balance, the bank cannot set the credit balance against the debits due to from the partner. Guardian. Whether a person has an account in the capacity of guardian, it is not to be treated in the same right as he is the owner of the bank. His own account. Trust. The fund held by a person in trust account to be treated in different right from his eligibility of an individuality. Joint accounts. If the account of a person shows debit balance, such dues cannot be recovered from his joint account that others. The debit should be certain demanded due and not a future or contingent debit, and whether to agreement to the contrary exists. It can be, however, be exercised for time-barren debits also. Guarantor. Against the guarantor, such rights can be exercised only when demand is made on the guarantor and his liability has determined. Garnishee order. The banker has right to exercise the right before garnishee order is made effective from the lawful debit which is due. Position of availability of right of set off to the bank. Deposit in the name of single person. Loan in the name of jointly with others. Status of availability of right available. Deposit in the name of partner in a firm. Loan in the name of partnership firm. Status of available right available. Deposit in the name of single name. Loan in the name of single name. Status of availability of right available. Deposit in the name of proprietor. Loan in the name of same name. Proprietor partnership firm. Status available. Deposit in the name of joint account. Loan in the name of one of joint holder. Status not available. Deposit in the name of trust. Loan in the name of trustee. Status not available. Deposit in the name of trustee. Loan in the name of trust. Status not available. Deposit in the name of divided account of co. Care of. Loan in the name of loan account of care of. Availability not available. Deposit in the name of dividend account and co. Loan in the name of loan account and co. Status not available. Deposit in the name of minor. Loan in the name of guardian. Status not available. Deposit in the name of single person. Loan in the name of single person but different capacity, say trustee. Status not available. Deposit in the name of single person. Loan in the name of same person. Status of availability of right available. Short answer and questions for quick revision. Question number 1. Is it right of creditor to retain the possession of the goods and till discharge of debit? Is it which act and section defines it? Lien. Indian Contract Act section 170. Question number 2. Whether the creditor gets the right to retain the possession for which the dues have arisen or not. For other dues, it is called particular lien. Indian Contract Act section 170. Question number 3. Whether the creditor gets the right to retain the possession till all the amount due to the debitor are paid. It is called general lien. Indian Congress Act section 171. Question number 4. Right of lien is available where the relationship between the banker and the customer is that of creditor-debitor. Question number 5. Right of lien available where the loan of the recovered is due and lawful. Question number 6. Right of lien can be exercised by complying what conditions? Reasonable notice, goods, securities in possession, loan due and lawful loan and securities in the same name, same capacity, possession in normal course or business. This is the end of page number 10. Page number 12. Question number 7. Right of lien can be exercised in the case of debit banking. Debit being in the same name and the capacity as the security is. Give few examples of the same name and the same capacity. Securities of A, loan of A. Securities of A and B, loans of A and B. Securities of A, loans of A and B. Securities of A, loans of A and B firm. Question number 8. What is the various situation where the right of lien is not available? Securities not in same name capacity, name handled over for a specific purpose, capacity is not for the creditor or debitor, goods not received is normal course of business. Question number 9. Banker's lien is always a dash, lien in which is called and dash. Answer. Banker's lien is always a general lien which is also called an implicit lien. Question number 10. How much is the period of limitation in the case of right of lien set off? The limitation not applicable as the goods and the securities can be deposited of without intervening of the courts because they are in the possession of the creditor. Question number 11. What is the share of company are deposited with the bankers for safe custody? Lien cannot exercise for those share. Question mark. Why? Share kept for specific purpose where the relationship could not be of creditor or debitor. Question number 12. Lien is not available for bank deposit. Why? Lien is applicable for goods and securities whereas the depositor and neither goods or not securities. Question number 13. If a customer left for some security by mistake, the banker's lien cannot be exercised. Why? Question mark. The relationship here is that of trustee, beneficiary and banker is undergoing obligation to return the goods to the actual owner. Question number 14. What is the security of the in the name of trustee for the loan of a trust? The lien cannot be exercised by criteria of same name, same capacity not fulfilled. Question number 15. On the securities relating to the partner of the loan of partnership firm, the lien can be exercised. Why? Partnership have joint and several liabilities. Question number 16. What is negative lien? When owner, debitor, undertakes not to dispose of the asset without consent of the creditor. Question number 17. What kind of legal right is available to the creditor for the given negative lien? Answer. No legal action possible since no legal charge has been created in the favor of creditor. Question number 18. What time is available to the company to get an particular of lien registered in the case of negative lien? Filling of particular is not ready for negative lien as per Company Act 1956. Question number 19. What is it mean by the right of set-off? Combining of two or more accounts for the purpose of final statement where at least one account is in one debit and one in credit. Question number 20. Where the right of set-off is defined. Not defined in any act, it is a result of contractual obligation. Question number 21. When the right of set-off can be exercised. Death / insolvency / lunacy of borrower / recipient of garnishee or attachment order. Question number 22. For exercising the right of set-off, what conditions should be fulfilled relating to loan? Account should be of same customer and his same capacity. Question number 23. In case of what kind of relationship the right of set-off could be exercised? Creditor / debitor and debitor / creditor simultaneously. Question number 24. On what does the right of set-off could be exercised? Bank deposit. 25. If the depositor is joint account and the loan is in single name, can right of set-off exercise? If yes, no / why? No, account is in the same name and the same capacity. 26. Whether the loan is in joint name and deposit it is in same name, the right of set-off can be exercised. Question mark why? Joint liability is to be discharged by the borrower jointly and severally. Question number 27. What is the essential condition for the exercising the right of set-off? The relationship of creditor and debitor and creditor same name, same capacity, reasonable notice, loan due and lawful. End of page number 12. Page number 13. Question number 28. Whether a split right of set is available in the term deposit which is yet to mature. Answer. Right is available but can be exercised on maturity. Question number 29. Whether the right of set is available on the deposit related to the guarantor. Yes, but recall notice will be required to be given to make the guarantor liable on the loan. Question number 30. What is the essential condition to be fulfilled for exercising the right of set-off on the deposit relating to a guarantor? Set-off can be exercised if demand is made on the guarantor and his liability has been determined. Question number 31. Right of lien is available on goods and securities. Right of set-off is available on depositor. Question number 33. Section 59 to 61 of Indian Contract Act related to right of appropriation. Question number 34. Whether the debitor has deposited the sum of money and has an also direction as whether the money is to be what the bank has to do. If the bank accepts the borrower's direction, the bank creditor must be fulfill the condition. Section 59. Question number 35. Whether the debitor has deposited the sum of money and has not directed as to whether the money is to be appropriated, what the bank has to do. Question mark. Creditor, that is, bank can apply its own discretion. Section 60. Question number 36. Whether the debitor has deposited the sum of money and has not directed as to whether the money is to be appropriate and bank also does not decide to do whether there is a appropriate, what will be assumed. Payment shall be applied in discharge of debts in order to time. That is, first debit is deemed to have been repaid first. Section 61. Question number 37. Rule of Clayton. Clayton. Clayton case is the line of which section of Indian Contract Act? Section 61. Question number 38. As per rule of Clayton case, which is the pre-assumed on deposit of some amount in the debitor's account, whether there are more than one loan account. First credit wipes out first debit till it is fully paid. Question number 39. Which kind of account the rule of Clayton case is applied? Cash debit / overdraft, that is running accounts. Question number 40. What does the situations whether the rule of Clayton case has been applied. Debt/insolvency or intestacy of the borrowers or joint borrowers partners in the firm of insolvency or guarantor. Question number 41. What is the precaution is to be taken by banks to avoid application of rule of collateral's case? Answer. Bank stops the operation in the account and fixes the determination and borrowers and guarantors liable partners withdrawal of the guarantor. Question number 42. Whether the FDR is set to mature and its amount is to be used for repayment of loan by bank by the given the notice, what kind of right is exercised by the bank? Right of appropriation. True, false. Question number 43. Bank cannot avail the general and particular lien simultaneously. True. Question number 44. For their labor charges, a goldsmith or a cobbler holds the good under general lien. False. 45. For separate agreement is required to create a general or particular lien. True. 46. Banker's general lien applied to all goods and securities during course of bank business. True. Question number 47. Good received inadvertently by the bankers are also subject to matter of lien. False. Question number 48. Banker's lien is available on securities given for safe custody. False. Question number 49. Whether the customer deposits the goods for a specific purpose, the lien is available. True. Bank can exercise the lien on all matured debts. False. Bank cannot use the right of lien whether the used a set of garnishee order and attachment order. Under section 31 of Negotiable Instrument Act, bank is under obligations to honor the check issued by the customer if the stipulated conditions are fulfilled. The obligation, however, is not applicable with either the garnishee order or an attachment order is received by the bank. End of page number 13. Page number 14. Garnishee orders. Provisional of insurance of garnishee order has been made under section 60 of the Civil Procedure of 1908. The procedure is described in the rule of 46 of order XX1 21 of the schedule of the Code of Civil Procedure. What is garnishee order? This is an order issued by the court on the request of the credit of the attachment of funds of the judgment debitor available with the bank. The creditor and those requested orders is issued is called judgment creditor. The debitor is called judgment debitor and the banker is judgment debitor on whom this order is issued is called garnishee. Effect of garnishee is a relationship between the banker and the customer is suspended temporarily, and as long as the garnishee order is in force, banker is under no obligation to pay the check and judgment debitor up to the amount of becoming attachable. But it is amount is specified, the order will apply on the specific amount only. A stage of implementation. Garnishee orders are implemented in two stages: order nisi and order absolute. Order NISI nisi. So this nisi court seeks the banks to advertise as to why the fund in the account as judgment debitor should be attached by the meeting of obligation under the judgment creditor. The receipt of the order nisi, bank is stop honoring customer's check and customer in the advice to in the order of immediately to avoid his honoring and checks issued by him. At this stage, the bank recovers its own due first and subsequent inform the court about remaining balance available for the attachment. Order absolute. After the bank submit its explanation, the court may issue the absolute order. The order attach amount of judgment creditor deposit with the garnishee bank, and receipt of this order bank remits funds and judgment debitor the courts without production of any book or issuing of any receipt. Cash in which garnishee order is applicable. Capacity. These accounts should be held in the same capacity in which the order is issued. For instance, joint account are not attachable for order of the same or one joint account holder. The creditor's account, the proprietor's account and the proprietorship account are considered one of the account for this purpose. Type of deposited account. Garnishee order attachment all deposit depends on the judgment of creditor and which credit balances in the relationship between the debitor and creditor, whether the other the payment SB or ACA, saving back or current account, or become the more due to the payment of future FDRs where the amount is payable on the maturity. Amount not withdrawn. It is also applicable whether the customer has given notice to withdraw any amount but the amount has not been actually withdrawn. Issuance of token of the customer will be affect the application garnishee if payment is not actually be affected. Order of the head office. Garnishee order will be applicable on the branch even if it served on its head office, provided head office is given reasonable time to intimidate the concerned branch or more than one branch within court jurisdiction. Hence, it is not a foreign branch. Joint account. If garnishee order is received the same two persons both having the same joint account, such account will be attachable in the order to name. This individual account will be covered under the order if the order in the same name of the person. Joint account will be attached even in the case of former survivor, although the order may be in the name of former. Frimer's account. Frims account. In garnishee account is served on the account if the partner Frims account and individual account of partnership are attached as a legal and joint of servers. Transfer of amount. If the customer has made a request of the transfer of sum of the account and entity therefore have been made into bank's book, garnishee order and the applicable provided advice is not sent to the customer. Deceased. Funds belonging to the deceased customer are still available with the bank in the name of deceased customer. Case in which garnishee account order is not applicable. Marked goods for payment. For the amount of check marked by the bank as good for payment, a specific sum, it is applicable for the specific amount mentioned in the order is not applicable beyond the stated amount. Cash credit / overdraft account. It is not applicable on the limit sanctioned irrespective of the fact whether the limit are partially or fully utilized, since relationship in this case is creditor or debitor and not debtor creditor. Checks presented is clearing. If a check has been received through the clearing house but time for returning the clearing has expired, the order of this amount will not be made effective. Page number 15. Amount deposited after order. It is not available for amounts deposited into the account after the order has been received by the banker. Different name in order. If the name of the judgment debitor mentioned in the order does not match with the name on banker's record, the order will be inapplicable. Joint accounts. Where all the joint holders are not judgment debitors named in the order and the joint account is not attachable. Insolvents. Orders in the name of insolvent person who do not attach his account as the funds are vested in the receiver or official assignee. Single partner. If the order received in the name of individual, the partner of firm, only his individual account will be attachable. Firm's account will not be attachable. Payment already made. Where the bank has already made the payments before the order is served, it is not applicable. Similarly, if TT has been sent by debiting customer's account, order will not be applicable if telegram has already been issued. Assigned amounts. Where the customer has assigned any amounts to the third party, the banker has duly received the notice of assignment. Garnishee order will not apply to this amount. Trust account. Account held in trust for order issue in the individual liability of the trustee. Funds in other capacities, funds, goods or money held by the bank other than a debitor, such as a safe custody, safe depositor, locker, funds, interest, checks or bills sent on collection, sale proceeds on shares, securities, still to be received, notice deposit, uncleared balances in saving or current account, credit received after recipient of garnishee account. Right of set off of garnishee orders. On recipient of the garnishee order, NISI, bank is entitled to recover its own duties first by exercising its right set off. New topic. Attachment order. Income tax attachment order issued by the income tax authorities under the section 226 of the Income Tax Act 1961. Attachment order can be issued under the Act such as Wealth Tax Act, Sales Tax Acts of different states, DRT Act, etc. Kinds of accounts. Subsection 3I of Section 226 of the Act authorized income tax officer to attach any debit due to which may be payable at the time of attachment order or afterwards, and also any amount received subsequently. Hence, it attaches present credit balances, and all deposit accounts include FDR, that is yet to mature proceeds in instruments in collection when received, that is future credit also. Action on recipient. On recipient of such order, customer should be given notice and customer should be intimate about payment made to tax authorities. Joint account. If income tax attachment is received on one of the joint account holders, the share of the joint account holder in such case shall be presumed to be equal until contrary is proved. Thus, this is such a case, amount lying in the joint account will be attachable pro rata subject to mention of fact on the order that a copy thereof been sent to joint account holders. The fact that the amount of the joint account was payable to either of the survivor or otherwise will not matter. Vague orders. Vague orders. A specific amount must be mentioned in the income tax attachment order. A vague order without mentioning any specific sum will not be treated as a valid order. Payment against order. For making payment of amount attached under income tax attachment order, production of passbook, deposit receipt of any document would not be necessary. However, of the payment made, the banker will be a recipient of thereof. Failure of the bank. If the bank fails to comply with the income tax attachment order, it shall be deemed to be an assess in default in respect of amount specified in order. Decrease in / insolvent. Fund in the accounts of decreased customer are attached. Partnerships. Fund in the partnership's firm's account not attachable for the order of the partner's account. Right of set off and attachment order. On recipient of the order, bank is entitled to recover its own first of excise by right of its own off there where the amount is due and action has been initiated. Garnishee and attachment order. Particulars. Authority, garnishee, complete code, attachment, revenue / tax authority. Particular under which act? Garnishee Civil Procedure Code 60, Order 21, Rule number 46. Attachment Relevant Act, Section 226 of Income Tax Act of the Income Tax. End of page number 15. Page number 16. Depositor, judgment debtor, assess. Nature of order. In the two stages, that is order nisi and the order absolute, issued as a payment order, issued to recover personal dues to creditor, dues of the government, who issues component called government authorities have their authority to recover government dues. Bank, judgment debtor, assi debitor. Amount may be mentioned specifically. Applicable to which amount? Clear amount with the garnishee at the time of recipient, for time of or after recipient of the order. Applicable to which account? All deposit account. FDRs, both mature and yet to mature, both mature and yet to mature. Right of set off, available for lawful and due debits. Joint accounts, order single name, not applicable. Applicable pro rata. Account of a order in his name where he is not applicable, or of agent or trustee. Applicable. Order in partnership name and account in partner's name. Applicable. Joint account order same joint name. Applicable. Order in the name of partner, trustee, executor, liquidator, director of a company, etc. Not applicable for the accounts in the name of firm, trust, company, that is, account in fiduciary capacity. Not applicable for accounts in the name of firm, firm, trust, company and accounts in the fiduciary's capacity. Decreased. Applicable. Execution proceed can't be stopped after death. Applicable. Insolvent. Not applicable. Recovery is to be made by the receiver in preferential order. Not applicable. Recovery is to be made by the receiver in preferential order. Undrawn CC or OD limit. Not applicable. Not applicable. Where the order is received simultaneously are pending for payment. Preference to attachment. Preference to attachment. Failure to implement the order. Bank will be deemed to judge debitor. Assess in default. Limitation. 12-year being execution of decree. 30-year being government dues. Applicability on FDR as collateral security. Not applicable. Not applicable. Very short question and answer for quick revision. Question number 1. Garnishee order issued by a civil court. Question number 2. Garnishee order is issued under signature of Section 60 of Code of Civil Procedure. Question number 3. Garnishee order is issued by the following procedure given under the order dash and the rule dash garnishee. Order XXI rule number 46 of the Civil Procedure. Question number 4. If the garnishee orders procedure, the bank is known as garnishee. Question number 5. Garnishee order become applicable where the banker-customer relationship is that of debitor-creditor, include the credit balance in cash, credit or overdraft account. Question number 6. On which kind of account the garnishee order is applicable? Please state. All the types of deposits accounts, that is saving, current, terms deposit. Question number 7. On which balance or the amount the garnishee order is not applicable? The amount is received after recipient of the order. Question number 8. If the order is nisi in garnishee order received, what action is taken by the bank? Bank stops honoring customers' checks and customer is advised the order. Bank also examines where it has exercised its rights of set off. Question number 9. When garnishee order is applicable on the amount of credit advice received by the bank branch but do not credit to customer's account, garnishee order is applicable. End of page number 16. Page number 17. Middle point of short question and answer for quick revision. Question number 10. When garnishee order is applicable on the amount of check which has been debited to the account and credit advice has been prepared by the bank branch but not sent to the collecting branch, garnishee order applicable. Question number 11. When garnishee order is applicable on the amount of check which has been debited to the account and the time of returning in the clearing system is still available, answer: order will be applicable. Question number 12. Will garnishee order is applicable on the amount of check which has been debited by the account and for which the payee has handed over the token to the payment to the cashier? Answer: order will be applicable. Question number 13. What is the position of the applicable of the garnishee order on a joint account whether the account is single name in the account is either survivor or former or survivor? Will it make the difference? Answer: order will not be applicable in any of joint account situation. Question number 14. Will the garnishee order is applicable on the decreased customer's account? Answer: if the funds are available, the order will be applicable as it discharges the liability of the account holder. Question number 15. Will the order be applicable on the insolvent customer account? Not applicable. Question number 16. If the amount has been deposited in the account of recipient in order to whether the order would be applicable on that amount? Not applicable. 17. Whether right of set out available in case of garnishee order has been received? Yes, the bank is entitled to recover its own duties. Question number 18. Will the order be applicable on credit balance in the CC or overdraft account? Yes, debitor/creditor relationship at that time. Question number 19. Attachment order can be issued by whom? Give names of 3-4 authorities. IT authorities, DR Act, sales tax authorities, customer duty authorities. Question number 20. In the attachment order process, the bank is known as debitor of the SIC. Question number 21. Attachment order becomes applicable where the banker-customer relationship is that of debitor-creditor. Question number 22. On which kind of account the attachment order is applicable, please state. Deposit account. On which balance, question number 23, on which balance or the amount the attachment order is applicable? Credit balance is a time of recipient of order and future credit also. Question number 24, whether attachment order is received, what action is taken by the bank? Answer, bank should give notice, stop operation, exercise right of set off. Question number 25, whether attachment order is applicable. Question number 25, whether the attachment order is applicable on the amount of credit advice received by the bank branch but do not credit customer account. Answer, attachable. Question number 26, whether attachment order is applicable on the amount of the check which has been debited by the account of credit advice has been prepared by the bank branch but not sent to the collection branch. Answer, attachable. Question number 27, whether attachment order is applicable on the amount of check which has been debited by the account and the time of returning in the clearing system is still available. Answer, attachment. Question number 28, whether attachment order is applicable on the amount of check which has been debited to the account or for which the payee has handed over the token for payment of the cashier. Answer, attachable. Question number 29, what is the position of the application of attachment order on a joint account which the order is single name and the account is either or survivor or former or survivor or will make the difference? Attachment in case of all the joint accounts but no pro rata basis. Question number 30, will the attachment order be applicable on a deceased customer's account? Yes, as long as the funds are lying in the deceased account. Question number 31, will the attachment order be applicable on insolvent? Answer, no. End of page number 17. Page number 18. Question number 32, if the amount has been deposited in the account after recipient of the attachment order, whether order would be applicable on that amount? Answer, yes. Question number 33, whether right of set off to be available in the case of attachment order has been received? Answer, yes. Question number 34, will the attachment is applicable on credit balance in the CC or overdraft account? Answer, yes. 35, in case of joint accounts, on what basis the attachment order is applied? Pro rata. 36, in case of attachment order, the payment is made on recipient of attachment order and the instructed in the attachment order. Question number 37, in case of garnishee order, the payment is to be made on recipient of order absolute bracket, that is order for payment. Question number 38, if a bank fails to implement the garnishee order, what is the liability of the bank? Answer, contempt of court. Question number 39, if the bank fails to implement the attachment order, what is the liability of the bank? Answer, bank shall be deemed to be SCC in default. Question number 40, if the attachment order is garnishee order are pending for implementation, which order would be given priority and why? Attachment order will be given priority because it relates to the government dues. Question number 41, if the attachment order can be implemented on a term deposit which is yet to mature? Answer, yes, order is applicable. Question number 24, if the attachment or garnishee order applicable on drawn balance in CC or OD account? If yes, why? If no, why? No, the loan account is not attachable as relationship is not of debitor and creditor. Question number 43, write down the circumstance under which the relationship between the banker and the customer get terminated. Answer, close of account, death, intestacy of the customer, etc. Question number 44, state whether the following is true or false. Garnishee order can be issued by High Court only. False. Attachment order is issued by Revenue Authority of Government. True. Where payment is pending made and both orders are received, the priority is given to the court order. False. Bank can decide the conflict claims of joint account holder in case of joint account with referring to the court. False. for future credit transaction in the case of recipient of garnishee order and customer can open another account. True. Liquidation account can be attached in the case of company in liquidation which garnishee order is received. False. For dues of the partner in case of attachment order, account of firm can be attached. False. Mandate and power of attorney. New topic. Mandate and power of attorney. Through mandate or power of attorney, a person can appoint the other person as agent. Hence, only a person component to contract can execute a mandate or power of attorney. While legally minor and insolvent can be appointed agents, lunatic person cannot be. Mandate. A mandate is a simple letter of authority can be an account holder in case of joint account signature by all, in case of partnership signed by partners, all partners, Cartra in case of HUF, bracket close. Directing the bank to permit the person named in the authority to operate the account. Other purpose. It may also be make, draw, accept or withdraw, otherwise signing bills of exchange and other instruments. What is included? Mandate to operate the account do not include the power of overdraw or close the account. End of page number 18. Page number 19, last page of this unit. Topic: stamping. Definition. Mandate do not require a stamping or witness. In case of illiterate person, it requires attestation/witnessing. Termination. Mandate gets terminated in case of death, insolvency, insanity of the account holder, revocation by the account holder, and non-acceptance of or refusal of the person to act as agent or death of the agent. New topic: power of attorney. Power of attorney is a document through which general power, including for bank accounts, are vested if the amount given a public notice. A general versus a specific power of attorney. It may be general or specific. In case of general power of attorney, the agent is empowered to do many acts. In case of a specific, it is for a single or limited number of actions. However, action should be specific and nothing should be inferred. Exclusion should be in the presence of notary public. Who can execute and who cannot be POA, power of attorney holder. Person not component to contractory, minor, insolvent or insane, cannot execute a power of attorney or mandate, but minors or insolvent person can become a power of attorney holder. Insane person cannot be appointed attorney. Stamping and witness. It requires to be witness and stamping of person, state government, prescribably duly. Outside India. Power of attorney executed outside India must be stamped within 3 months of the recipient in the India. Registration and registrar of assurance is not compulsory, where it is executed in the presence of notary, magistrate, court, judge, etc. It can be accepted without any inquiry as per section 85 of Indian Evidence Act. A style of signatures. Power of attorney holders to sign as per pro, which indicates his limited authority to sign on behalf of the principal. PER/PRO. Revocation. It can be cancelled, express revocate by the principal and up to his death instantly, insolvency or liquidation. In the case of many OR, many company or death or instantly, which is not insolvency of the agent. Joint power of attorney holders. They can act jointly. Check signed before termination by the agent. It can be paid if otherwise in order. Where it is registered, it can be revoked with a letter instrument only. Against third party, the conviction takes effect when it comes to their notice. Section 208 of Indian Contract Act. Coupled with interest, it cannot be cancelled. Same power of attorney given to the bank for recovery of book debts to adjust the account in case of advance against book debts. Section 202 of Indian Contract Act. Delegation. Agent cannot delegate the authority unless he has been authorized to delegate to substituted agent. Bank branches are a record particular of mandate or power of attorney. End of page number 19, end of unit 2.